An asset hearing in Oklahoma is a court hearing used after a judgment has been entered. The purpose is to allow the judgment creditor to ask the judgment debtor questions about income, bank accounts, property, vehicles, employment, business interests, and other assets that may be available to satisfy the judgment. An asset hearing does not usually decide whether the judgment was right or wrong. That issue has normally already been decided. Instead, the hearing focuses on collection. The court wants the debtor to answer questions under oath so the creditor can determine whether garnishment, execution, liens, or other collection remedies may be available. Understand why you are there. If you're the judgment debtor, you are attending because the creditor has a judgment and wants information about your assets. Creditors may be trying to find wages, bank accounts, vehicles, or other property they could use to collect the judgment. If you are the judgment creditor, you are attending because the court has ordered the debtor to answer questions about assets. This is your opportunity to obtain information that may help you collect the judgment. Do not ignore the hearing. The most important tip is to appear. Oklahoma law allows the court to order a judgment debtor to appear and answer concerning the debtor's property after a final judgment has been entered. If the debtor does not appear after being properly served, the court may issue a contempt citation or bench warrant. Ignoring an asset hearing can make the situation worse. Even if the debtor cannot pay the full judgment, appearing and answering honestly is usually better than failing to appear. Bring the documents requested. The order setting the asset hearing may tell the debtor to bring certain documents. These may include recent pay stubs, bank statements, tax returns, vehicle titles, deeds, insurance information, loan documents, business records, retirement account statements, benefit statements, and information about other assets or debts. Read the order carefully before the hearing. If documents are requested, bring organized copies. If a document no longer exists or is not available, be prepared to explain why. Be honest and direct. An asset hearing usually involves sworn testimony. That means the debtor must answer truthfully. Guessing, hiding assets, giving incomplete answers, or falsely denying property can create additional legal problems. If you do not know the answer to a question, say so. If you need to look at records to answer accurately, say that. A clear and honest answer is better than an inaccurate one. Know what property you own before attending. Review your financial situation. Be ready to answer questions about where you work, how you are paid, what bank accounts you use, what vehicles you own, whether you own real estate, whether anyone owes you money, whether you have business interests, and whether you recently transferred property. A debtor should also be ready to explain joint accounts, shared vehicles, property titled in another person's name, and money received from family members. These issues often come up when a creditor is trying to determine what belongs to the debtor and what does not. Understand exempt property. Not all property can be taken to satisfy a judgment. Oklahoma law protects certain exempt property from collection. Exemptions may apply to certain wages, household goods, retirement benefits, Social Security benefits, workers' compensation benefits, some personal injury proceeds, and other protected property depending on the facts. However, exemptions should not be assumed. If you claim that money or property is exempt, be prepared to explain the source of the funds and provide records. For example, if money in a bank account came from Social Security or workers' compensation benefits, bank statements may be needed to trace the funds. Do not transfer or hide property. A debtor should not transfer property to a spouse, relative, friend, business partner, or related company just to avoid collection. Oklahoma law allows the judge, pending the hearing and further order of the court, to prevent the judgment debtor from alienating, concealing, or encumbering non-exempt property. Transfers made to avoid a creditor can lead to additional litigation. They may also make the debtor look dishonest at the hearing. If property was sold, gifted, transferred, refinanced, or retitled, be ready to explain when it happened, why it happened, what value was received, and where the money went. Be careful with payment agreements. Sometimes the parties discuss a payment plan at or after the asset hearing. A payment agreement can be useful, but it should be realistic. A debtor should not agree to payments they cannot make. A creditor should not rely on a vague promise without putting the terms in writing. A clear agreement should state the payment amount, due date, method of payment, where payments should be sent, what happens if a payment is missed, and whether collection efforts will pause while payments are current. Know that small claims judgments may also lead to asset questions in Oklahoma small claims cases. The court may help secure a listing and description of the judgment debtor's assets if collection becomes necessary. Oklahoma small claims law also provides forms for an application and order to appear and answer as to assets and interrogatories to be answered by the debtor. This means an asset hearing is not limited to large civil judgments. Even a small claims judgment can lead to post-judgment collection proceedings if it is not paid. Dress and act like you are in court. An asset hearing is still a court proceeding. Arrive early, dress appropriately, be respectful, silence your phone, and address the judge properly. Bring a pen, paper, identification, and organized documents. If you are nervous, make a short list of key facts before you arrive. For debtors, list your employer, income, bank accounts, vehicles, property, monthly expenses, and exempt income sources. If you are the creditor, list the questions you need answered and the documents you want to review. Talk to an Oklahoma attorney before the hearing.